The Indian Penal Code, or IPC, is the primary criminal law of India. It is a comprehensive code intended to cover all substantive aspects of criminal law. The IPC was enacted in 1860 during the British Raj and continues to be enforced today. The code is frequently amended to keep pace with the changing socio-economic environment and technological advancements. The IPC is divided into 23 chapters, comprising a total of 511 sections. These sections define various offences, both cognizable and non-cognizable, and stipulate the punishments for these offences. The IPC encompasses a wide range of criminal activities, including offences against the human body, property, public order, and the state. Sections 300 and 302 of the IPC deal specifically with offences affecting human life. Section 300 defines the offence of murder, while Section 302 prescribes the punishment for the offence of murder. These sections represent the cornerstone of India's legal framework for dealing with homicide cases. They are crucial for ensuring justice and upholding the right to life. The IPC is not merely a static document, it is a living testament to India's evolving legal landscape. It reflects the nation's ongoing commitment to justice, fairness, and the protection of its citizens. Understanding the nuances of the IPC, particularly sections like 300 and 302, is vital for comprehending the functioning of the Indian legal system. Section 300 of the IPC defines murder. It states that culpable homicide is murder in certain circumstances. These circumstances elevate the crime from culpable homicide to murder. It is essential to understand the elements that constitute culpable homicide before delving into the specifics of murder. Culpable homicide is defined under Section 299 of the IPC. Section 300 outlines 4 specific situations when culpable homicide amounts to murder. Firstly, if the act by which the death is caused is done with the intention of causing death. For instance, John shoots Raj with the clear aim of killing him. Secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause death. For example, Seema stabs Meera in the chest, knowing that such a wound is likely to be fatal. Thirdly, if it is done with the intention of causing bodily injury as is sufficient in the ordinary course of nature to cause death. This means that the offender need not have specific knowledge of the likelihood of death. It is enough if the injury intended is objectively likely to cause death. For example, a group of people brutally beating a victim, leading to his death. Fourthly, if the person committing the act knows that it is so imminently dangerous that it must, in all probability, cause death, or such bodily injury as is likely to cause death, and commits such an act without any excuse for incurring the risk of causing death, or such injury as aforesaid. For example, planting a bomb in a crowded place, knowing that it will likely kill someone. Understanding these 4 situations is crucial for distinguishing between murder and culpable homicide not amounting to murder. The prosecution must prove beyond a reasonable doubt that the accused's actions fall under one of these 4 clauses to secure a murder conviction. The fine line between culpable homicide and murder often hinges on the element of intent. Section 300 of the IPC meticulously outlines the circumstances in which culpable homicide transforms into the more serious offence of murder. This section highlights the crucial role of intent in determining the gravity of the crime. One of the critical aspects of Section 300 is its focus on the knowledge and foresight of the accused. The section emphasizes that even if the accused did not specifically intend to kill, their actions can still constitute murder. This is particularly relevant in cases where the accused inflicts injuries knowing that such injuries are likely to cause death. For instance, if someone repeatedly strikes another person on the head with a heavy object, the court may infer that the accused intended to cause bodily injury sufficient to cause death. Even if the accused did not specifically aim to kill, their knowledge of the potential consequences of their actions elevates the crime to murder. The concept of imminently dangerous act is another crucial element of Section 300. This clause captures situations where the accused engages in an act, knowing its highly dangerous nature and the likelihood of causing death. For instance, driving a vehicle recklessly in a crowded area, even without the intent to kill, can be considered murder if it results in death. Section 302 of the IPC prescribes the punishment for the offence of murder. This section is inextricably linked to Section 300, which defines murder. Once it is established that an act constitutes murder as per the criteria laid out in Section 300, Section 302 comes into play to determine the appropriate punishment. The punishment for murder under Section 302 is either death or imprisonment for life. The section provides for the most severe punishments available under Indian law, reflecting the gravity of the offence. The judges have the discretion to award either of these punishments based on the specific circumstances of each case. Several factors influence the court's decision while choosing between the death penalty and life imprisonment. These factors include the brutality of the crime, the vulnerability of the victim, the motive behind the murder, the criminal history of the accused, and the possibility of reformation. Section 302 also clarifies that even if life imprisonment is awarded, the offender shall not be released from prison unless the appropriate government remits the remainder of the sentence. This provision underscores the seriousness with which the Indian legal system views the crime of murder.